record in 2024 CR 420, State of Kansas versus John Raymond Hanna. Please announce appearances.
Darren McGee on behalf of the state.
Your Honor, Darren Patterson, appear on behalf of John Hanna. Mr. Hanna does appear via Zoom audio-visual from the Butler County Jail. Judge, this is a case where I am requesting the court to allow me to withdraw. I would just tell the court that communication has broken down to the point where counsel and client are not able to discuss the case any further, and would ask substitute counsel be appointed, or Mr. Hanna may hire counsel. I don't know.
Mr. Hanna, are you able to hire counsel?
I'll have to look into it, but I'm pretty sure I can figure something out.
Well, if you can hire an attorney, you should hire your own attorney. But you apparently told me or someone else that you couldn't afford an attorney early on, and you received court appointed.
No, I was saying that I have been in court. I've been pretty much in a situation where I was supposedly incarcerated, to where I haven't been able to contact my family members. What I explained. That's how I explained that. I don't like contacting my family members from facilities like this. Because I had problems still my mail and identity theft, so I don't really condone talking to my family member and giving out addresses in a situation like this with these people that don't have what they call a 922E or a 912E jurisdiction. So we can continue on if you want to try to. I just a jurisdiction right now.
Well, what in the world is a 912E jurisdiction?
I'm the judge. You're supposed to figure it out.
Right here, we are witnessing a textbook example of attorney-client tension. When a lawyer publicly says they can't represent their client effectively, it's serious. Patterson is basically waving a red flag. I cannot advocate for you anymore. Meanwhile, Hanna contradicts himself, first claiming he can't afford a lawyer and then implying he can figure one out. This is a critical moment. It shows the defendant's unpredictability and foreshadows why the courtroom is about to descend into chaos. The judge handles this delicately, but you can almost see him calculating the patience meter ticking down. How would you handle a client who refuses clarity at every turn?
I can't figure out something that doesn't exist.
It does exist, but I'm saying if you don't exist, I understand if you be the. I mean. And then, and the other thing, dude told me that the court, that he said it was going to be 3 days from now. He didn't say it was going to be today.
Who told you that?
He did. The attorney did.
All right. Mr. Regier, do you know what this, tell me that number again. What is that number you're citing, sir, for jurisdiction?
922E.
922.
And you got a 912E too.
And a 912.
Yeah, that establishes the corporate courts are illegal in the United States, pretty much.
Corporate courts are illegal?
Pretty much illegal in the United States, yeah. Pretty much.
Okay, that's...
On the Brady violation as well. Maryland versus Brady.
I know Brady.
Yeah, Maryland versus Brady, yeah. And when we addressed this issue, you should have started with Maryland versus Brady. When you addressed me before anything, you're supposed to address me with Maryland versus Brady.
All right, stop it right now. I'm not going to keep taking your abuse.
Okay, I'm not going to take abuse. I don't want to lock double handcuffs on.
All right, you're going to stop it. You're going to settle down, and you're going to show respect for the court.
It's my house.
Stop it right now.
My house. I built it, whatever. I built it. I'll pay out this bill.
You will stop it right now. I understand we have a screen between us.
Yeah, okay. I know I don't even know if you're in the courtroom, for real. Let's do a video.
Well, I think I understand why Mr. Patterson, a very experienced, very competent, qualified attorney, can't work with you.
I got a couple of them too.
Well, if you got them and you can afford them, there's no reason the taxpayers ought to be paying for your attorney.
No, I'll pay. What do you mean? The taxpayers ain't paying for my attorney. Point blank. Quit telling my intelligence, please.
Now, things get wild. Hanna starts tossing around terms like 912E jurisdiction and corporate court conspiracy theories. The judge asks, plainly, what that even means, and Hanna doubles down, insisting these rules exist, even chastising the judge for not knowing them. For viewers unfamiliar, this is classic sovereign citizen rhetoric, language that sounds legal but has zero basis in law. The courtroom here becomes a collision of reality versus fantasy. The judge remains composed, trying to ground the conversation in actual Kansas law, while Hanna spins his own alternate legal universe. It's both frustrating and surreal. Who else is secretly fascinated by how far someone can stretch pseudo-legal claims?
Well, I'd order them to take you into custody, but you're already there.
I know I'm in custody, and you went up on my bond in custody. How do you do that? Oh, that's what Department of Justice right there. Thank you. Are there any more things to issue, Mr. Jay? What's the
You
prosecutor's
don't
name?
address me. Stop it. Mr. Patterson, you are most definitely excused from this case for the reasons cited. You may journalize the dismissal.
Yes, Judge.
And I don't see any need to point anyone else because the defendant's telling me he can afford an attorney. What do you need to get?
Brace yourself, because this is where authority clashes with delusion. Hannah outright refuses to follow the court's lead, claiming this is my house, threatening to pay out the bill himself, and dismissing the judge's instructions. The courtroom tension peaks as the judge warns he could be restrained, but Hannah is already in custody, so the threat barely lands. This scene is both absurd and telling. A defendant living in his own world while the legal system tries to operate in ours. It's a reminder that courtroom management is not just about law, it's about controlling chaos, and the judge here does it with remarkable restraint.
What he's talking about.
To him too.
Stop talking. Do you, Mr. Regier? Mr. Regier, do you know what he's in reference to when he says 922E jurisdiction and 912E jurisdiction?
Wrote that down backwards.
Judge, I think those are pursuant to federal rules of procedure.
Well, we're not in federal court, so I don't keep myself.
But you have to go by my constitutional rights for a due process. For to be a corporate court, it could because you're financed by federal money. This is not financed by the people here in this county. You get government grants to run this place from the feds.
Where in the world did you hear that?
It's the truth.
Where'd you hear it?
I don't matter what I heard because I do my own research. I'm not answering that question. I would plead the fifth on that question.
Well, I don't know what he's talking about.
Exactly.
It's a federal rule, but this is not.
So we can bring up the competency of the court right now. We'll have to turn just on that. Do we need any issues, Mr.
You so that you can get a new attorney, and you told me you were going to hire your attorney. Is that right?
Yeah, I said I will figure it out. Is what I said.
All right, so you'll figure it out. You don't want the court to address another court appointed, right?
Pretty much not. Not with that competency level.
Not a court appointed attorney. So let's have the notes reflect. He does not want a court appointed attorney. He questions the competency level.
I'm going to go after the prosecutor now.
Oh, you want to go? You said you want to go
against prosecuting. Thank you. Put that on the record. Terry Clark got on paper. Thank you, Mr. Prosecutor.
So what did you say? You want to go after the prosecutor?
No, I said we will holler at the Department of Justice. We'll talk to him. Go after his accusation is what I said. Confront his accusation with the Department of Justice. That's what I said. Thank you. Is there anything else I can get back to where I was legally incarcerated at?
Deputy, do you think that does he normally behave competently? I'm wondering if I need to do a competency evaluation. Anyone want to be heard on that?
I've already had one.
In this case, you have?
No, I have one on my federal case. I felt competent because everything I stated with it, it's already backed by law.
Well, I am going to, on my own motion, order that there be a competency evaluation.
Here's a crucial pivot point. Patterson is officially excused, leaving Hannah to navigate his case alone or hire someone new. The judge immediately orders a competency evaluation, signaling that Hannah's behavior raises serious questions about his ability to participate meaningfully. Hannah resists, claiming an evaluation is unnecessary because he's already passed one in federal court. But the courtroom record shows otherwise. His statements, logic, and wild claims paint a completely different picture. This moment illustrates why courts must balance a defendant's rights with the practical need to ensure they understand the proceedings. Could you imagine having to evaluate competency while someone insists they're the ultimate legal authority?
That can be done in the county jail because I'm not sure you're tracking, Mr. Hannah.
Good for you. I don't care if you think that or not because I can decline that. And if I'm found incompetent, that means you can't do what? You can't put me in.
continue the jury trial because he needs a new attorney. The time will count against him.
So they have to do illegal commits, take people's property, identity theft. Yes.
And we need to do a competency evaluation. We will set this over. When's my next available jury trial date, Jen?
February 23rd for the pretrial, February 25th and 26th for the jury trial.
And Monday.
You said 26th, and did you say 25 and 26?
That's correct, Your Honor.
Okay. All right. So the defendant is ordered to be here February 23rd for pretrial and February 25th and 26th in person for a jury trial. And then when I get the motion on file for competency, then we'll set the competency hearing before then, of course.
Hannah goes next level conspiracy mode, claiming the Kansas state court is illegitimate because it allegedly receives federal grants. He refuses to reveal his sources, invoking the Fifth Amendment. The judge patiently explains that state courts follow state law, not federal regulations. This exchange highlights a critical theme. Misinformation can completely warp someone's perception of due process. Hannah treats every legal fact as optional, filtered through his personal research. And as spectators, we are witnessing a fundamental clash between evidence-based law and unfounded assertions. It's a case study in how personal belief systems can derail even the most straightforward legal proceedings.
I see you have had a U.S. Marshal hold on federal charges. That was back in April of last year. I see there was a previous failure to appear.
I was in Butner on evaluation because I had to get rid of the last attorney I had. His name he was going under a fake name. His name was Kurt Burrows, and his name was Beeman Howard. So I had to remove from my case because he wasn't even who he said he was.
Well, I don't know.
Party mistake. Yes, conflict of interest. Yeah, I've had to remove from the case.
Well, I don't know either of those names. That must be on your felony charges.
Yeah, felon possession firearm, which I got a settlement on. Then I got a settlement when I was in federal prison for it. Got a settlement for it. I've been illegally detained. It's in the law books.
This is now a religious experience. You have a belief.
Right here, and then your assistant.
Yes. All right.
Chair over here. You can pull it out if you need me to. Actually, I'll just have a seat right there. All right.
All right. This is the matter of the state of Ohio versus Timothy Gordon II. It's case 25 CRB 1229. And you're Mr. Gordon. Is that correct, sir?
I'm representing the estate. I'm the executor of the estate trust, and I'm here to settle the matter at hand.
You didn't answer my question.
I am not the all capital straw man. I am the living man.
Well, there's somebody sitting in this chair who's a living, breathing individual.
Yes.
Correct?
Yes, sir. And I'm not a corporation like you guys are. I'm not. We
Well,
do business
you
together.
may believe that, sir, and
No, that's the
I'm
truth.
not going to try to get you to believe other than what you believe.
Yeah.
But you, according to the record here, is you would be Timothy J. Gordon II,
The living man.
and we're here today on a bench trial in this matter. Are the parties ready to proceed?
The state is, Your Honor.
All right. And Mr. Gordon, you're not represented by counsel.
No, I do not consent to these hearings. I do not wish to contract,
I hear what you're saying, and
sir.
I'm sitting up here prepared to hear any evidence regarding what occurred
There
in
is no
this
probable cause in
case.
the whole case. I'm sorry. I
I'm
apologize.
speaking.
Apologize.
Yeah. And we're going to go to a trial in this matter today. Whether you wish to be if you wish to be represented, you can be represented.
Next, Hannah really leans into his self-proclaimed legal expertise. When asked about a law degree, he claims he doesn't need one. He's been educated by top attorneys, personally knows a Supreme Court judge, and is close to famous lawyers' families. The courtroom staff remain professional, but viewers can see their disbelief. This is a classic mix of arrogance and ignorance that makes sovereign citizen cases so challenging. It's not just defiance, it's the belief that he understands the system better than trained professionals. Watching this, you have to ask, how do courts keep order when a defendant's self-perception is completely untethered from reality?
Prerogative, but it is your prerogative. Here's how trials are conducted, Mr. Gordon. The state of Ohio, Ms. Yeager, who represents the state of Ohio, will be presenting evidence through witnesses who are sworn. And those witnesses will take the witness stand here and tell the court whatever Ms. Yeager asks of those witnesses. At the conclusion of their testimony, you have the opportunity to ask questions regarding the testimony of the individual, and that's called cross-examination.
Yes, sir.
If you have questions, please make sure that they're relevant to the testimony and not something that's irrelevant. All right?
Yes, sir.
Once the state has presented its evidence, you may present whatever evidence you wish to present. You may testify on your own behalf, but you're not required to do so. However, if you choose to testify, you yourself will be sworn, and then you can tell the court what you want to tell the court. You can do it from right where you're seated. You don't have to come up to the witness stand.
Here, the judge provides a masterclass in courtroom procedure. Witnesses are sworn, testimony is collected, and cross-examination is explained clearly. Hannah, as usual, is only partially listening, throwing questions about paychecks and jurisdiction. This segment shows the delicate balance judges must maintain, educating a self-represented defendant while ensuring the trial continues efficiently. It's an important reminder. The law is procedural as much as it is substantive. Without structure, chaos takes over, and in cases like this, the courtroom almost feels like a game of herding cats. Would you be able to stay focused if the defendant questioned everything in sight?
Sure.
Is this a court of records?
Yeah, we're recording right now.
And I got one more question. Can I ask who signs your paychecks?
State of Ohio signs my paychecks.
And can I ask who signs your paychecks?
I assume it's the city of Newark.
I moved for dismissal.
And I'm going to deny that. Congratulations. Now, you can then testify in this matter. And
Things take a sobering turn when the judge questions Hannah's mental competence to stand trial. Deputies weigh in on typical behavior, and Hannah insists he's already passed a competency evaluation. But his logic and arguments suggest otherwise. The judge orders a new evaluation, which Hannah resists, claiming it's illegal. This segment reveals the tragic side. What appears as arrogance may actually mask delusion. For viewers, it's a glimpse into why courts prioritize competency checks, to ensure defendants can meaningfully participate, understand charges, and protect their rights. It's both a legal and human story, highlighting vulnerability hidden behind defiance.
No, Your Honor, we'd waive that.
all right. And Mr. Gordon, do you have an opening statement?
Yes.
Yes, go ahead.
I feel that this should be dismissed under several different reasons and causes, but there was no probable cause to stop me. I was just walking down the street, on my way to work, minding my business, not breaking any laws whatsoever, walking down the street, and police officer pulled in front of me, stopped me, and demanded to know who I was, that's not the law. I don't have to tell him who I was. I was doing nothing wrong whatsoever. There is no probable cause for me to be in this courtroom sitting here right now.
Okay. Appreciate that. Ms. Yeager, you may call your first witness.
Thank you. The state will call Officer Wingate.
Please remain standing, just raise your right hand. Do you solemnly swear or do you affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Please be seated. For the record, please state your full name and spell your last name.
Lindy Wingate, Wingate.
And then please give your work address.
39 South 4th Street, Newark, Ohio.
Thank you.
All right, you may proceed, Ms. Yeager.
Officer, how long have you been employed by the City of Newark Police Department?
6.5 years.
6.5 years. And were you working on September 19th of this year?
Yes.
And what shift or what hours were you working?
First shift, 7:30 a.m. to 5:30 p.m.
Okay. Were you wearing the appropriate uniform like you are in court today?
Yes.
And were you operating a marked cruiser with a working visible light bar?
Yes.
Have you had all required training and certifications required by Newark Police?
Yes.
To wrap it up, this courtroom session was a whirlwind of defiance, pseudo-legal arguments, and procedural navigation. Attorney Patterson withdraws, citing a total breakdown in communication, while Hannah navigates a complex maze of his own making. The judge expertly manages authority, sets competency evaluations, and maintains trial dates, all while ensuring due process. This case highlights the challenges courts face when balancing law, procedure, and unpredictable defendants. If you found this case as shocking and fascinating as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.